talk about what's going on in the Kaitlyn Conley case. This is Kaitlyn Conley on the screen. She's already had two trials. We're going to go through the backstory on that. And we're waiting to see if there's going to be a third trial. Over the past week or so, we've had a judge take issue with the prosecution team, a prosecutor step down, and now the prosecution team is moving to disqualify the judge. So let's get into it, starting with the 411 on Kaitlyn Conley's first two trials. We're going to go all the way back to July 22nd, 2015, when Mary Yoder, the mother of Kaitlyn Conley's ex, Adam, was found dead at work. The prosecution's theory was that Kaitlyn killed Adam's mom to get back at him after a breakup. Now, this video is focusing on prosecutorial misconduct and the judge calling it out, and then the prosecution's office taking issue with the judge. But I'm going to link this article from Spectrum News 1 with a day by day recap of the second trial, where Kaitlyn Conley was convicted of manslaughter. And let's look at these two quotes here. So, after 2 full days of jury deliberations, we get a mixed verdict. Jurors find Conley not guilty of second-degree murder, but found her guilty of the lesser-included charge, manslaughter in the first degree. This decision came 2 hours after jurors sent a note to the judge telling them that they were deadlocked, but they were sent back to continue. And the first trial had ended in a hung jury. Conley's defense attorney, Frank Policelli, during this second trial says, "I don't think there was any circumstantial evidence to show she actually poisoned Mary Yoder. So I think that the jury compromised, and I think that their verdict was not a just verdict." Then from the assistant district attorney, Lori Lisi, for the second trial, "I think they worked really hard. I think they really spent time going over the evidence, thankfully. I think it was an excellent verdict, and I'm happy with it. I know the family's very happy with it." So let's talk about the appeal. So on January 31st of this year, 2025, a New York State appeals court ends up overturning the conviction. Now we're going to get the 411 on this appeal from Colin Miller. I'm going to link to his write-up in the description. And also I suggest that if you use X, follow him over there. You might already know of his podcast, the Undisclosed Podcast. But not only does he cover a bunch of cases, but he works within some of the most interesting cases, including this one. So in this case, he provided pro bono assistance to Conley's appellate attorney, Melissa Schwartz, and he gives us his analysis. So he says Kaitlyn Conley worked at the chiropractor office of Dr. Mary Yoder, who was also the mother of Conley's ex-boyfriend. The state's theory of the case was that on the day in question, Conley poisoned Dr. Yoder's lunch with colchicine, a plant-based alkaloid which may be used to treat and prevent gout and some other inflammatory conditions, but which can be lethal in larger doses. And here Colin Miller is going to talk about the first prosecution, and there's an important difference. Something new happens in trial 2. In trial 1, we get a bunch of patients that testify about Dr. Yoder seeming to suffer from what could be consistent with the side effects of colchicine poisoning, particularly on the day in question. This is important for the state's timeline because symptoms of colchicine poisoning can start to show within 2 to 8 hours. We get this awesome context here from Colin Milner about, hey, there's actually an issue with this timeline. So the defense ends up calling a different patient. So prosecution calls a bunch of patients, then defense calls a different patient. And when it comes to this patient, Holly Hiltz testified that she had an appointment with Yoder at 10 or 10:30 a.m. on July 20th, 2015. That's the date that Dr. Yoder is poisoned with the colchicine. Hills testified that during this appointment, Dr. Yoder's energy was a little lower than normal, and she had redness in the inside of her eye around her eyelid in the bottom part, kind of like when you have hay fever or get ill. Hills testified that Dr. Yoder was low energy. During Hills' testimony, it was disclosed that Hills had given a statement to investigator Mark Van Namme on February 25th, 2016. In the interview, she said her appointment was at 10:30 a.m. and that Dr. Yoder's lower eyelid appeared to be a little red, kind of like she was coming down with a cold. Now, as Milner points out here, this is problematic because if it takes 2 to 8 hours for the symptoms of colchicine poisoning to start showing themselves, and the theory is that Kaitlyn Conley poisons the mom at lunch, how was one of the first appointments that morning? How was she already showing these symptoms? So this first trial ends in a hung jury, and according to Milner, most jurors thought that the jury was split 10-2 in favor of a not guilty for Kaitlyn Conley. So now, trial 2, right? I said there's going to be a contrast here with trial 1 that's important for this appeal. So trial 2, state retries. Conley has a new attorney. Trial's proceeding, and this new defense attorney doesn't call Holly Hiltz. this witness that may have been pivotal to the 10 jurors that didn't think that the state had met their burden, that they hadn't proven beyond a reasonable doubt that Kaitlyn Conley poisoned Miss Yoder during the lunchtime break at their job. The new attorney also failed to move to suppress evidence improperly retrieved from Conley's cell phone. So this is stuff that was not part of the first trial. Now, hopping over to the opinion from the New York State Appeals Court, we've got their memorandum here that the defendant appeals by permission of this court from an order that denied her motion pursuant. So her other attempts at a direct appeal had been denied previously. But the state appeals court agrees to hear her case. They lay out this context here that during the course of its investigation, the Oneida County Sheriff's Office, OCSO, obtained a warrant authorizing it to seize defendant's cell phone and, without unnecessary delay, return it to the court. So the sheriff's office thereafter seizes Conley's cell phone, but instead of returning it to the warrant issuing court, they take it right to a cybersecurity and forensic center, do this forensic examination and memory extraction. And there we go. We've got a bunch of stuff. So this examination revealed, among other things, that the words poison and colchicine showed up multiple times in that cell phone user's dictionary, and that an email account used to acquire colchicine had been logged into on the cell phone. Now, with this information, the sheriff's office uses this information to continue their investigation, including eliciting an admission from Kaitlyn Conley that she had purchased a prepaid debit card that had been used to acquire colchicine through an online chemical vendor. And that chain of events led to them indicting Kaitlyn Conley. And then Conley raised an ineffective assistance of counsel argument, arguing that her counsel failed to move to suppress this evidence, this cell phone search and everything that was extracted thereafter. In other words, because this cell phone search exceeded the scope of the warrant. So the warrant said, you can get the device, but you've got to bring it back to the court. Well, OCSO ended up getting this device and just, hey, run here, go do this extraction. But trial counsel for the second trial didn't object to this evidence. They didn't move to suppress it. And on this basis, Court of Appeals here agreed. They reversed the judgment. So they say, we agree with the defendant that she was denied ineffective assistance of counsel inasmuch as defense counsel failed to properly move to suppress the evidence obtained from her cell phone. Indiscriminate searches pursuant to general warrants were the immediate evils that motivated the framing and adoption of the Fourth Amendment. They go on to say that a person's cell phone now contains at least as much personal and private information as their home, and thus indiscriminate searches of cell phones cannot be permitted. As defendant correctly contends, the forensic examination and memory extraction of her cell phone's contents exceeded the scope of the warrant, which only authorized OCSO to seize the cell phone and return it to the court. Furthermore, the warrant failed to meet the particularity requirement, inasmuch as it, among other things, did not specify the items to be seized by their relation to designated crimes. Thus, we conclude that the defendant established that a motion to suppress would likely be successful and that defense counsel had no strategic or otherwise legitimate explanation for not moving to suppress the evidence. They also conclude that the failure was sufficiently egregious and prejudicial as to compromise Conley's right to a fair trial. And although much of the information recovered from the improper search of the cell phone was later also available to the prosecution through an alternative source, that source wasn't available at the time that the sheriff's office used what they got from this search and then this extraction that wasn't covered by the scope of the search warrant. They used that information to elicit an admission from the defendant. So without that search and that extraction, they wouldn't have that admission. So it's all fruit of the poisonous tree. The appeals court here supports this. They say that there's repeated assertions by the prosecution during the second trial that incriminating evidence of defendant's efforts to research and ultimately acquire colchicine had been recovered directly from her personal cell phone. So prosecution throughout the trial was reiterating, we got it from that extraction, we got it from that extraction, we got it from that extraction, and not from an alternate source. So reinforcing again that fruit of the poisonous tree argument. So they vacate this judgment. And now for this week's crazy. So this is July 25th. This is coming from Luke Raydell. He's writing for WKTV. And we've got a judge finding that an assistant district attorney violated court order in the Conley grand jury. So they're trying to get this third trial going. They're trying to get this indictment after this conviction's reversed. And what do we have going on? So we've got Judge Bernadette Clark telling Oneida County District Attorney Todd Carville that his office violated a court order by presenting sealed evidence to a grand jury. When she was set free back in February, an attorney for Conley asked Clark to seal the records in her case, including evidence used in the trial that led to her now overturned conviction. At the time, Carville did not object to the seal before it went into effect. So I would imagine this includes the stuff from the cell phone extraction and maybe the admission that stemmed from the extraction. But according to the transcript from a closed door court hearing on June 10th, when his office went to represent the case to a grand jury months later, Assistant District Attorney Nicholas Fletcher used that sealed evidence in violation of the court's order. So they presented to a grand jury anyway. The transcript shows Carville argued, this is him arguing to the judge, trying to defend his office and what they did at this grand jury hearing. He argued that he was ambushed by the request from Conley's attorney to seal the records in the case. Judge Clark disagreed, saying that Carville had a full and fair opportunity to oppose the sealing on February 4th, yet failed to do so. I know I didn't object and I apologize, Carville responded. I fall on the sword for that, Your Honor. Carville, the DA, also argues that this was a shrewd move by the defense counsel. In response, defense counsel Melissa Schwartz said, if knowing the law, applying the law, and protecting my clients is shrewd, then here I am, Judge, standing before you. I'm shrewd. So Clark, the judge, then ends up conducting a private review of the grand jury proceedings. And she comes back and she says, it is unmistakable to this court that sealed evidence has been presented to a grand jury. Carville had tried to tell the court before she did this review, before the judge did this review, that I've not been involved in the grand jury presentation, so I don't know what has or hasn't been presented. Someone else did it. I don't know. I have no idea. Fletcher handled the presentation, court's records show. Towards the end of May, he reached out to Lieutenant Richard Paul of the Oneida County Sheriff's Office, asking him to request the records be unsealed as part of a, quote, ongoing investigation. So we can't use the things in this case, but let's go have the sheriff's office do it. Paul submitted an affidavit to the court that was drafted by then County Attorney Amanda Cortez-Calatz. Cortez-Calatz also submitted a memorandum of law and supplemental memorandum of law in connection to Paul's request that contained inaccurate case citations. We're going to get to this, chat. We're going to get to this. She resigned from that post on July 16th after a, quote, professional error, according to a statement from Oneida County Executive Anthony Pacenzi. Amanda, she just entered our story here. She used inaccurate case citations. We're going to find out they don't exist. And then she steps down. So her time in this storyline, as far as we're concerned, very short, in and out. Paul testified during the June 10th hearing about his affidavit. Schwartz, as the attorney for Conley, asked, is anyone in the Oneida County Sheriff's Office personally assigned right now to investigate Ms. Conley's case? Paul responds, no. Judge Clark rules that the alleged ongoing investigation was nothing more than a pretext for this application to unseal the records for the district attorney's office to represent the case to a grand jury. She said the timing of the filing by the sheriff's office makes little to no sense and doesn't track. She says despite bearing the name of the Oneida County Sheriff's Office, it is in reality an application on behalf of the district attorney. The facts available to this court show that the application has been made at the district attorney's office request and for the district attorney office's benefit. So that's what the judge finds. She denies the motion to unseal the records. And while these hearings and motions and these rulings are all playing out, Oneida County DA ends up moving to remove the judge from the case. So on June 25th, Todd Carville files this motion and he cites the court's demeanor and responses, a continued failure to remedy a ruling, and comments made at a June holiday party that indicated judicial bias. In this motion, Carville says that during the people's argument, the court interjected frequently and became loud in her responses. At times, the town appeared hostile towards the people. He also said the people had no opportunity to file an objection to the sealing of evidence, with the requisite 5 days' notice, as they were put on notice the day the order was executed. Carville goes on, stating that the order to seal imposed by the court was in direct conflict with itself, as the people had been granted the ability to represent to the grand jury. In doing so, this court cannot suggest that it was in the interest of justice to seal evidence in this case unless the court's inclination was to render the people's opportunity to represent futile, he wrote. Additionally, we have quotes here included from December 2025. I guess this is the holiday party that may indicate bias and violate judicial law. So let's see. Let's see what we get here. So former Oneida County District Attorney Scott McNamara said in a deposition that while at a holiday party at the Oneida Indian Nation, Judge Clark expressed her opinions on the case in a way he felt was biased. This is a quote. "I expressed my opinion of her guilt, and Judge Clark expressed her opinion of her innocence," McNamara writes. Judge Clark was making comments that led me to believe that she felt Conley was wrongly convicted, as she stated that Mary Yoder's husband was the person responsible for Mary's death. Oh, oh. McNamara added in his deposition that he doesn't know who started the conversation about Conley's innocence or guilt. And this is set to be heard, this motion for recusal is set to be heard August 7th at 11 a.m. So we'll be looking out for that one. And last but not least, we've got this fake case citation story. I feel like every week I'm hearing about some story somewhere where somebody's caught citing to cases that don't exist. And, when you submit a filing to a court, you're signing off on what you're submitting. So you shouldn't be putting anything fake in there. And this time it's a government attorney doing it. It's an attorney from the Oneida County District Attorney's Office. So we've got Luke Raydell again, and they do some great work here because they go and they search a bunch of documents to pull out what they could find. News Channel 2, this is WKTV, reviewed hundreds of pages of documents from the past 6 months in the Conley case, including the following 7-page memorandum of law filed by Cortese Collatz on May 28th. In the memo to Judge Bernadette Clark, she wrote on behalf of the Oneida County Sheriff's Office for the evidence against Conley to be unsealed and cites another case to bolster her argument. Quote, "Matter of New York City Police Department v. District Attorney of Kings County." That case doesn't exist, according to the court and an independent review by News Channel 2. Oneida County Executive Anthony Pacente announced the appointment of a new county attorney on July 16th. Pacente did not provide specifics on Cortese Collatz's reason for stepping down and said only that she'd, quote, "made a professional error, took responsibility for it, and I have accepted her resignation. She will continue to serve this government in a different capacity." And we don't get the context here on what that different capacity is. So court records show that in addition to the inaccurate memo submitted on May 28th, there is another supplemental memorandum of law on June 5th. And here's the bullet points. 6 cases are cited that do not exist. 2 statutes are quoted that do not contain the quote cited. 3 cases are quoted that do not contain the quote cited. 2 statutes are cited that do not represent the principle for which they were cited. And 2 cases cited do not represent the principle for which they were cited. So Judge Clark strikes that June 5th filing from the record. Cortese Collatz was ordered to not file any further papers in connection with the unsealing request. Nobody wanted to return a comment. So there we go. What do you think? Turning this over to you. We've had 2 trials. It seems like the state, the government is pursuing a 3rd trial. Do you think we're going to get there? We'll see. I think the next important date is August 7th, where that motion to have the judge step down is going to be heard. But with that being said, a lot of moving parts here. It's almost like a case within a case at this point. And although Kaitlyn Conley was released in February of this year after her conviction in the 2nd trial was overturned, she has spent 7 years in custody already. So lots of food for thought there to munch on. Let me know what you guys think. I hope everybody has a great and wonderful day, and take care. Bye, guys.